All right, thank you so much. I will go ahead and give the secretary the nod that we're ready to begin recording on her end. All right, welcome to the Senate Committee on Growth and Infrastructure. Will the committee please call the roll?
Senator Brooks? Go ahead. Senator Pickard?
I am here.
Senator Spearman? Senator Hammond? Chair Harris?
I am here. There are 2 members present. So we will open up we have 3 members present.
I'm sorry I missed my spot in the roll call. Here.
Not a problem at all. Thanks for arriving. We now have quorum. So we are ready to get started. We'll go ahead and mark members present as they arrive, and I will try my best to give a little verbal indication for the secretary to note. All right, as always, we'll start with a couple of reminders. Please be courteous and respectful with others during the meeting, even if you disagree with another person's position. For those participating on Zoom, please be sure to mute your microphone when you are not speaking. First on the agenda today is Senate Bill 18, which revises provisions governing penalties for certain violations relating to public utilities. I'll go ahead and welcome my former colleagues, Garrett Weir and Stephanie Mullen, to present the bill. Please proceed when you're ready.
Thank you so much. And good afternoon, Madam Chair and members of the committee. For the record, Stephanie Mullen, Executive Director for the Public Utilities Commission of Nevada. I am here to present SB 18, which is intended to provide the Commission with a fining authority adequate to motivate adherence to the regulatory requirements that the Commission is tasked with enforcing. SB 18 proposes to amend the Nevada Revised Statutes, Section 703.154, 703.380, and 704.640 to enhance the Commission's authority to impose administrative fines for the purpose of deterring noncompliance with statutes, regulations, or commission or court orders that govern the conduct of certain persons subject to the Commission's jurisdiction. SB 18 would adjust the fine amounts under NRS 703.154 from $1,000 to $200,000 a day for each day of the violation, and from $200,000 to $2 million maximum for any related series of violation. These amounts match our current authorities under the federal pipeline safety regulations, and this is mostly a housekeeping adjustment. We have worked with the Nevada Propane Dealers Association on this. The requested fine amount under NRS 703.380 is proposed to increase from $1,000 to $100,000 per day for each day of the violation, not to exceed $10 million for any related series of violations. And finally, the current fine amounts under NRS 704.640 is set at $500, and the request is to increase this amount to $50,000. The Commission proposes to increase the administrative fine amounts for several reasons. First, the fine amounts are very dated. The legislature established the current maximum fine amounts under NRS 704.154 and 703.380 in 1981, and in 1979 for NRS 704.640. While perhaps appropriate 40 years ago, those amounts are no longer sufficient to create the necessary disincentive for violating important statutes, regulations, and orders that ensure the safety, reliability, and affordability of utility service throughout the state. Not only have utility revenues increased dramatically since 1981, but the potential impact of the actions or inaction of PUC regulated entities has also grown. Take, for example, the potential consequences of failing to implement commission-ordered fire mitigation measures. Increased property values and proximity of development to fire zones has created a far greater risk of and costly property damage, including loss of life. Notably, the California PUC fined Pacific Gas and Electric $1.9 billion in response to the Paradise wildfire. And that's an amount 190 times larger than the maximum fining authority that we're requesting in SB 18. Additionally, the nature of the Commission's regulations of utilities has evolved over the past 40 years to now include the implementation and oversight of numerous programs and activities designed to achieve state policy objectives. The Commission is increasingly being tasked with enforcing a transition to innovative approaches that differ from how things have been done for a very long time. Change is often met with resistance, and the regulator responsible for enforcing the change needs to be equipped with adequate authority to ensure compliance. Second, there's a proven track record of increased fining authority resulting in decrease in the amount of seriousness of violations. In 2019, Nevada experienced its lowest gas excavation damage rate in recorded history. Nevada has seen a steady decline in the number of gas damages since the 2015 legislative session, when the Commission's fining authority was increased. Since 2008, the Commission has collected and deposited over $3.2 million in fines to Nevada State General Fund. Over the last biennium alone, the Commission has collected over $1.1 million. Unlike PUCs in many other states, the PUCN receives no financial benefit from imposing administrative fines, as fines are deposited to the general fund and they do not affect the agency's budget. The Commission's only interest in imposing fines is maintaining compliance with its governing laws, orders, and regulations. It is also important to note that the Commission already has authority to put regulated entities out of business by revoking or suspending certificates and licenses. SB 18 provides for a less severe but still serious financial penalty. The PUCN has a long history of measured application of its fining authority. When maximum penalties increased for violations related to pipeline safety, there wasn't an abuse of that enhanced authority. In fact, nearly every penalty has been stipulated to by the penalized party. Anyone who is assessed a fine is entitled to a hearing and due process, which involves consideration of the factors outlined in statute. And if the PUCN fails to consider the specific facts of a case, its decision will be overturned through the judicial review process. Utilities are further protected against excessive penalties by the PUCN with their overarching statutory duty, which is to balance the interest of customers and shareholders of public utilities. Now, we understand that concerns have been raised by some of the companies who would be subject to the proposed enhanced fining authority, and we plan to work with them on revised language, providing further protection against disproportionate penalties. However, ultimately, the purpose of this bill is to empower the PUCN to impose fines that are concerning to those companies. We don't want the maximum fine amount to be something that they're comfortable paying, nor do we want the fining framework to be so prescriptive that it allows for companies to engage in a cost-benefit analysis as to whether it makes business sense to comply with the law. That said, we're hopeful that we can agree on meaningful changes to ensure that the punishments fit the crime. In conclusion, the Commission requests your support of SB 18 to provide an important tool to ensure the safety, reliability, and affordability of utility service, and to also ensure the effective implementation of public policies adopted by the Nevada Legislature. Garrett Weir, the PUCN's General Counsel, and I are happy to answer any questions that you have regarding this proposed legislation. Thank you.
Thank you. I'll go ahead and kick it off with a question of my own. Let's say last year, how often was the maximum fine sought by the Public Utilities Commission?
Stephanie Mullen, for the record. Thank you for that question. It's a great question. Actually, since the legislation was changed in 2015, we have never reached the maximum fining authority under the federal pipeline, which was the $2 million maximum that I discussed. We did levy a fine of approximately $500,000 last year. And prior to that, the max was approximately $300,000. And that was sometime around 2016.
And do you have the same information for these fines that we're seeking to increase today?
Stephanie Mullen for the record. We do. Unfortunately, the way we collect the fines that we've levied since 2008 is docket specific and not by fining authority. However, I do know that it is not often that we hit that $100,000 mark, but I'm happy to provide detailed information for you at a later date.
Do any of the members of the committee have questions? Vice Chair Brooks.
Thank you, Chair Harris, and thank you, Ms. Mullen and Mr. Weir for presenting this today. This builds upon Chair Harris's question that she just asked. And so is the reason that you hadn't maxed out on any of these fines, is it because the daily was too low, and that they just, whoever the violator was able to kind of fix their issue, or is it a settlement, or how is it that, you know, and I totally understand the justification for the fines that you're asking for. But I'm just curious, if you haven't maxed out, does that mean that the daily is too low, or you know, or is there just not a problem?
Thank you, Senator Brooks. For the record, Garrett Weir. I think it's a combination of factors. The daily amounts, with the revised, I mean, there are restrictions that the commission follows for that revised enhanced authority, which our staff does believe is sufficient as a deterrent to pipeline safety. But like with regard to the regulations or the statutes in 703, 380, the finding authority that we're attempting to increase fairly dramatically through this bill, there's not only are the limitations there, I mean, you know, we're not going to go above that, but we face compaction issues where I think the commission struggles with determining what to fine an offense where, say, $100,000 is the maximum is appropriate, but we don't want to send a message that that's as egregious a violation as something where there's loss of life or some sort of terrible outcome. So, you know, that it's really a struggle. You hope to have that larger range to assess an adequate penalty when something is bad, but not the worst possible type of violation. And so that's really why we're seeking that range, where we could, you know, you might see more fines that could be in that $100,000 range if that's an appropriate amount, but you know, it would be relative to a fining authority that's much greater.
I think that I understand that, and that you're kind of just moving the entire kind of grade, the all the way up, both ends of the spectrum, all the way up, so that it just kind of creates more incentive for good behavior at every level. Now, could you walk me through, Chair, can I follow up with another question? Could you walk me through how do you get to the max? Can you, like, can one violation get the max fine right now if that's what you levy, or does it have to be not more than the daily fine per offense over time in aggregate to achieve the max? Or can you just go straight to the max based upon the type of violation?
For the record, Garrett Weir, through Chair Harris to Senator Brooks. That's a great question, and the limitation right now, it is the maximum daily. So depending on the number of days for a related offense, I mean, we are restricted by that daily amount. So where you would see, you know, the ability to reach that maximum is if basically an offense or a violation goes undiscovered for a long period of time. You know, it's something more systemic, perhaps, but you know, the daily limits do restrict the commission's ability to max out. So it's in fact, that might be the more important cap, frankly, because a lot of the most egregious types of violations would perhaps you know, not have occurred over a long period of time. But things that are systemic, like a failure to take to do the take the kinds of actions that the commission requires in an order that looks at a period of several years. I mean, that's where you end up getting into those large numbers.
Thank you. Thank you, Chair.
All right, Senator Pickard.
Thank you, Madam Chair. Director Mullen, I'm just picking up, you answered all my questions when you called, and thank you, by the way, for you and Mr. Weir calling in advance, because you saved the committee a bunch of time and heartburn having to listen to me. But you did say one thing that kind of tripped me up a little bit. You started out by saying that the current limitations to the fines were set 40 years ago. And then you mentioned something in 2015 that I thought you said when these were updated. So I want to make sure I'm understanding we're looking at a change over 40 years, not a change over 5. Is that correct?
Yes, Stephanie Mullen for the record, through you, Chair Harris, to Senator Pickard. That is correct. The statute that I was referring to was some of our federal pipeline statutes, and it's in NRS 704.595, which was updated in the 2015 session, in addition to our one call laws, which were also updated that same year.
All right, thank you very much. Thank you, Madam Chair.
Oh, for the record, if I may, Madam Chair,
Sure.
just to Garrett Weir, just to add further clarification, the revisions in 704.595, they provided the exact finding authority that we're now seeking for pipeline safety. The commission actually has not been invoking its authority under the section that's addressed, section 1 of this bill, because we have the necessary finding authority elsewhere. So that section of this bill is really a housekeeping measure.
All right, thank you. And I enjoy the photographs behind you. They look great. Thank you.
And Madam Secretary, I've been remiss in noting that Senator Spearman and Senator Hammond have joined us. Please note their arrival. Are there any other questions from committee members? Okay, seeing none, we will go ahead and open it up for testimony. BPS, please start with testimony in support of SB 18.
Thank you, Chair. Callers, to testify in support of SB 18, please press *9 now to enter the queue. Once again, to testify in support of SB 18, please press *9 now. Caller with the last 3 digits of 860, please slowly state and spell your name for the record, and you may begin now.
For the record, my name is Mike Robertson, Mikeroberson. Thank you, Chair Harris, Vice Chair Brooks, and members of the committee. My name is Mike Robertson, and I'm a utility analyst appearing on behalf of the Bureau of Consumer Protection. We represent over 1.1 million residential, multifamily, and small business ratepayers and dockets before the Public Utilities Commission of Nevada. We thank the committee for this opportunity to voice its support of SB 18. We specifically support SB 18's increase to the maximum administrative fines the PUCN can assess against a public utility that provides any inaccurate or misleading information in a case before the PUCN. It is imperative that the information presented to the PUCN is complete, accurate, and timely. Lies, deceit, and deception have no place in our public hearings. As lawmakers yourselves, each of you understands that clearer and more accurate information not only contributes to a thorough and adequate analysis, but also ensures proceedings are conducted with the integrity and transparency that Nevadans rightfully expect and deserve. The BCP respectfully requests your support in ensuring integrity and the best possible outcomes in our public utility hearings, and join us in support of SB 18. Thank you.
All right, caller with the last 3 digits of 533, please slowly state and spell your name for the record, and you may begin now.
For the record, my name is Dylan Sullivan, DYLAN SULLIVAN. Chair Harris, Vice Chair Brooks, and members of the committee, good afternoon. I'm Dylan Sullivan. I'm a senior scientist at the Natural Resources Defense Council. We're a nonprofit environmental organization. We have around 25,000 members and online activists in the state of Nevada. I'm speaking to you from Reno today. NRDC supports SB 18 for two main reasons. First, we frequently intervene or otherwise participate in dockets at the Public Utilities Commission of Nevada. In most of these dockets, we are reviewing and reacting to something that utilities file. We spend tens of thousands of dollars, for example, hiring experts to help us understand what a utility company is proposing and what can be done within law and policy to improve it. Accurate information is key to the proper functioning of the regulatory process. If utilities intentionally misrepresent costs or misstate what they're actually doing or plan to do, we can't properly respond. And this bill would ensure that utility companies have an incentive to provide accurate information to the commission where it is needed to make good decisions. Second reason, to a large extent, Nevada is addressing climate change through our utility sector. Electric utilities are subject to the Renewable Portfolio Standard. We have energy efficiency and energy storage targets. We're probably going to have more in the future. These policies will be implemented through commission rules and orders, and we're not going to be successful at reducing pollution if violating these rules and orders is just another cost of doing business for utilities. In order to get effective compliance, the potential cost of a violation, and that means the chance of getting caught multiplied by the potential fine, needs to be a lot larger than the potential benefit to the utility of not complying. In summary, this well-crafted legislation gives regulators the tools they need and ensures that the regulatory process has good information. Thank you.
If you're just now joining us, please press *9 to enter the queue for testimony in support of SB 18. Caller with the last three digits of 732, please slowly state and spell your name for the record, and you may begin now.
Hello, my name is Kyle Davis. That's KYLEDAVIS, and I'm here today on behalf of the Nevada Conservation League. We are in support of the bill. I don't have anything more to add beyond what my colleague, Mr. Sullivan, had mentioned, so we'll just leave it at that. Thank you.
Chair, at this time, there are no more callers in support of SB 18.
Okay, let's go ahead and move to those who'd like to testify in opposition.
Absolutely. Callers, if you would like to testify in opposition to SB 18, please press *9 now to enter the queue. Once again, that's *9 now to enter the queue for opposition to SB 18. Caller with the last three digits of 816, please slowly state and spell your name for the record, and you may begin now.
Good afternoon, Chair Harris and members of the committee. My name is Deborah Gallo, Gallo, and I'm the Director of Regulatory Projects for Southwest Gas. Southwest Gas is opposed to the bill in its current structure. And although we appreciate the amendment proposed by the Public Utilities Commission and some of the modifications to the original draft that were included in that amendment, just want to state the Commission has been very open to working with us. And as Ms. Mullins stated, we'll continue to work together in development, hopefully of some additional language to address some of the concerns with the proportionality of the administrative fines proposed in the bill. Thank you.
Will the caller with the last three digits of 124 please slowly state and spell your name for the record? You may begin now.
Good afternoon, Chair Harris and members of the committee. For the record, Paul Moradkin, Moradkhan, Senior Vice President with the Vegas Chamber. The Chamber is opposed to Senate Bill 18 as originally drafted because of the significant change in the fine structure that has been proposed. Our concern being the precedent it would set. We do recognize the policy issue that's being trying to be addressed by the PUC, and we do believe we will be able to find a resolution to a revised fine structure. I would like to thank the PUC and their time for their conversations they've had with us. They've been very open and transparent, and we look forward to the continued dialogue with their staff. Thank you, Chair Harris.
All right, well, the next caller with the last three digits of 166, please slowly state and spell your name for the record, and you may begin now. Once again, caller with the last three digits of 166, please slowly state and spell your name for the record. You may begin now.
Chair Harris and members of the committee, for the record, Barry Duncan, BARRYDUNCAN, on behalf of the Nevada Taxpayers Association. The Nevada Taxpayers Association is to post the language in SB 18 as currently drafted. With that said, we stand ready to continue working on an amendment that meets the needs of the PUC as well as the regulated entities. I do want to take a moment to thank the PU staff for their time and willingness to work with all of the stakeholders. Thank you for your time.
Caller with the last three digits of 018, please slowly state and spell your name for the record. You may begin now.
This is Matt Morris, MATTMORRIS, representing the Nevada Resort Association. Thank you, Madam Chair, members of the committee. I just echo the comments that have already been made by my colleagues, expressing concerns over Senate Bill 18 as currently drafted. Certainly want to thank the PUC and Executive Director Stephanie Mullen, Garrett Weir, for being open and transparent and working with us on potential language that could clarify some of the broad language in Senate Bill 18 with regard to the terms inaccurate and misleading information. Certainly appreciate the opportunity to continue working with you on this bill, and that will do it for us. Thank you.
All right, Chair, at this time, there are no more callers wishing to testify in opposition to SB 18.
Okay, thank you. We will turn to testimony in the neutral position.
For anyone wishing to testify in a neutral position for SB 18, please press *9 now to enter the queue. Will the caller with the last three digits of 680 please slowly state and spell your name for the record? You may begin now.
Thank you, Chair Harris. For the record, my name is Tony Sanchez, and I'm the Executive Vice President for Business Development and External Relations for NV Energy. NV Energy supports the concept behind Senate Bill 18 before you today to update and modernize administrative fines that can be imposed by the Public Utility Commission. As the state of Nevada's largest regulated utility, we fully understand the importance of the Commission's enforcement responsibilities. However, NV Energy believes that the amount of the proposed fine increases, some proposed to be increased more than 100-fold, needs to act as a strong deterrent to the prohibited conduct, but at the same time, not be punitive. At NV Energy, we've been very fortunate to not have faced very often the prospect of a fine from the commission. Aside from a potential fine, reputational impact can be also a significant deterrent to prohibited conduct, something very important to our entire company. As the committee has heard, the structure of fines currently appearing in Chapter 703 have not been updated since literally 1993 and 1981. Those structures haven't been modified since, and we agree that they need to be updated. We believe that maybe a fairer approach would be to use the average inflation rate over the years and then apply that calculation to true up the numbers to 2021 values. For example, if an average inflation rate between 2 to 3% is applied, and you round the numbers up for ease of application, you could see $1,000 fine becomes $5,000, $100,000 fine becomes $500,000, and a $200,000 fine nears mid $700,000 range. We believe that approach can work to meet the objectives sought by the commission while making sure that the structure of fines is fair and in line with inflation. We have discussed this proposed legislation with the commission's general counsel and Director Mullen, and they've been very accessible and have taken many of our concerns into account. And I'd like to thank them for that cooperation and transparency. We'd like to continue to work with both of them and their colleagues at the commission to reach a consensus as we move forward that meets their objectives. Thank you, Chair Harris, and available to answer any questions.
For the callers that just joined us, if you wish to give testimony in a neutral position to SB 18, please press *9 now to enter the queue. All right, Chair. At this time, there are no more callers in neutral for SB 18.
Okay, thank you. I'm going to go ahead and just ask Ms. Mullen another question while I've got her on SB 18. Would you mind clarifying the status of the amendment that you that you proposed and is on Nellis?
Chair Harris, through you, this is Stephanie Mullen for the record. I believe Garrett Weir might be able to better address that question. Garrett, if you're free.
Thank you, Chair Harris. Garrett Weir for the record. Currently, we are comfortable with the bill as amended by our proposed amendment. However, we are more than willing to entertain suggestions and to work with parties, as we are currently doing, to ensure that there is a proper proportionality of penalties imposed, taking into account things like the impact of a violation as well as willfulness, making sure that the punishment fits the crime.
Okay, thank you. With that, we will go ahead and close the hearing on SB 18 and open up the hearing on SB 59. I'll go ahead and welcome you back, Mr. Weir and Ms. Mullen, to present on that bill whenever you are ready.
Thank you, Chair Harris. For the record, Garrett Weir. Thank you to Vice Chair Brooks and members of the committee for the opportunity to present Senate Bill 59, which is a proposal that addresses the judicial review of decisions of the Public Utilities Commission of Nevada. Just at the beginning, I'd like to make clear that this bill is not proposing to change the existing state of law in Nevada regarding judicial review of PUC decisions. It's simply intended to clarify what has been viewed as ambiguous language in appeals that we've had of cases in recent years. And we're trying to avoid unnecessary litigation that uses state and other private resources. We hope to provide clarity to give guidance regarding what is the types of cases that are eligible for judicial review, or the types of proceedings that are eligible for judicial review, as well as the briefing schedule that's applicable to judicial review of PUC decisions. So basically, there are two clarifications that we're proposing through this bill. The first would clarify that contested cases, decisions in contested cases, are that judicial review is limited to those decisions and wouldn't apply to proceedings that are not contested cases. That change to contested case in place of the more broad term proceeding is it conforms with the existing law in NRS 233B 130, the judicial review provisions that are applicable to every other or nearly every other administrative agency in the state. The only really other type of proceeding where judicial review would be appropriate other than a contested case would be a rulemaking proceeding. And there's already a mechanism that exists pursuant to NRS 233B for persons to challenge the validity of a regulation adopted by the commission. And that's NRS 233B 110. And they can seek declaratory order from a court on that issue, or declaratory judgment. Next, we are seeking clarification regarding the expedited briefing schedule applicable to these types of appeals. To provide some context, the reason that appeals of commission decisions or the judicial review of commission decisions was exempted from the process applicable to all other state agencies was to expedite that process, because there are real risks of rate impact harm to customers from prolonged, protracted litigation where decisions of the commission remain unresolved for a period of time. Specifically, if a case lingers on appeal before ultimately the commission's decision being reversed, let's say on a decision that the commission made to disallow the recovery of costs by a utility. That decision would not just result in the utility being able to recover those costs that the commission had previously said were unjustified, but it would also entitle the utility to seek the recovery of the time value of that money that it hadn't collected during the pendency of the appeal. So the faster that these cases are resolved, the less risk there is of ratepayer impact beyond just reversing the commission's decision potentially. So with that in mind, there are a number of provisions within NRS 703-373, the judicial review statutes that govern the commission's appeals of commission decisions. Briefing timelines are shortened. The time for courts, day numbers are shorter than they are for review pursuant to NRS 233B. You have explicit language such as appeals of PUC decisions taking precedence over all other civil matters in the court or before the court. So it's very clear that the legislature was pursuing a policy objective of expediting this review. And one of those policy considerations that we believe the legislature already made was to truncate the briefing schedule for these proceedings to where there's still due process, where you have the petitioner seeking judicial review and any other parties who want to support that, who also want to challenge the commission decision. They would file an opening brief, and then all of the parties who are respondents in the case who want to defend the commission's decision, they would then file an answering brief. At that point, the current language says that the action is at issue, which we believe was intended to mean that the briefing schedule is concluded. And it goes on to say that the parties should be ready for a hearing within 20 days. So after there's been that opportunity for both parties to file briefs, and then there's a hearing opportunity as well to gather further information. That ensures the due process that anyone challenging the commission order would need. constitutionally. Certainly, it is less briefing before the court than is contemplated for review of other agencies' decisions. But as I mentioned, that was a policy consideration that we believe the legislature previously decided. They balanced, on the one hand, the completeness or the thoroughness of the written record before the court versus the potential impacts to ratepayers of prolonged proceedings, and believed that it was the appropriate balance to truncate the briefing as described. So we're just wanting to provide clarity regarding that policy decision that we believe was already made by the Nevada legislature. And with that, I am happy to answer any questions.
All right, before I open it up for questions, I just want to make sure all of the members have the amendment for this bill as well in front of them, so that they are working on that version and not the printed version. And I don't see anyone saying they don't have it, so I will assume they do. And I'll turn to Senator Pickard for his question.
Thank you, Madam Chair. And Mr. Weir, thank you again for your presentation. You covered most of, I think, the questions I had before. The one thing, and I'm looking at the amendment where you changed from brief to memorandum. This is on, I guess it's section 1, sub 7. And I don't object to necessarily the change in language, although memoranda would be broader, and I'm okay with that. But the one thing that occurred to me after our conversation before was, what happens if a judge requests additional briefing? This statute would presumably preclude that, and I understand why the commission would want to preclude that, but sometimes judges will get into a spot where they need some additional information and they're going to request additional briefing. How does this language not preclude that? Shouldn't we, or should we add language to the effect of unless otherwise requested by the judicial officer?
Thank you, Chair Harris, through you to Senator Pickard. For the record, Garrett Weir. That's a very good question. I think the language would preclude a general further responsive pleadings being filed. I think a request for briefing on a discrete issue, I don't believe that we would likely challenge something like that. I think the existing language, I mean, the intent would be to expedite this process. I mean, my proposal would be that in that instance, that the judge ask those questions at hearing, and maybe even have a preliminary order or discussion with parties to prepare them for that discussion taking place during hearing. But as far as written briefing, additional pleadings would extend that timeline. So we probably would need to change the language if we wanted to contemplate a discrete briefing. The concern there is that could ultimately not save the time that we're wanting to save.
And I understand that. I just balk at taking the ability of a court, judicial officer anyway, to not be able to get the briefing he needs, particularly if he's trying to build a written record. So I would recommend that change if the chair is so inclined. But that's it. Thank you, Madam Chair.
Are there any other questions from members? Okay, seeing none, we will go ahead and open it up to testimony. BPS, please go ahead and open up for testimony in support of SB 59.
Thank you, Chair. Callers, if you wish to testify in support of SB 59, please press *9 now to enter the queue. Once again, for anyone wishing to testify in support of SB 59, please press *9 now. All right, Chair, at this time, it appears that there are no callers wishing to give testimony in support of SB 59.
Okay, let's go ahead and move on to testimony in opposition to SB 59.
Alrighty, if you wish to testify in opposition to SB 59, please enter the queue now by pressing *9. Once again, to testify in opposition to SB 59, please press *9 now. Caller with the last 3 digits of 018. Please slowly state and spell your name for the record. You may begin now.
Thank you, Madam Chair. Members of the committee, Matt Morris, Mattmorris, on behalf of the Nevada Resort Association. We are opposed to Senate Bill 59 in its current form, and again, we appreciate very much the bill sponsors' willingness to work with us. We've had some productive conversations about some of our concerns with SB 59, and really, to put it succinctly, it's really what we see as a separation of powers issue. We have concerns with replacing the term proceedings with the term contested case as defined in NRS 233, and we would think that this is a checks and balances and separation of powers issue. If a proceeding, for example, is improperly noticed, and as a result, a customer or an interested party does not have the opportunity to participate in agency proceedings, then that individual may be deprived of adequate due process and the ability to seek recourse through the judiciary. SB 59 could arguably be interpreted as restricting ability to seek judicial relief, and that's really the essence of our concern and the opposition. But we're continuing to work with the bill sponsor on potential language, and we appreciate that opportunity. Thank you very much.
Chair, at this time, there are no more callers wishing to testify in opposition to SB 59.
Okay, we will open it up, please, to testimony in the neutral position.
For anyone wishing to testify in a neutral position for SB 59, please press *9 now to enter the queue. Will the caller with the last 3 digits of 048 please slowly state and spell your name for the record? You may begin now.
Good afternoon, Madam Chair, members of the committee. Stephen Cohen for the record. I share some of the concerns noted during the presentation and Q&A. I did submit a proposed amendment, unfortunately, just a little while ago to the committee manager, so it may not appear on Nellis yet, but I stand ready, willing, and able to work with the committee and or sponsor to address the concerns. And with that, Madam Chair, thank you, and I yield.
Chair, at this time, there are no more callers in the queue for a testimony in the neutral position for SB 59.
Okay, we will go ahead and close the testimony, and I'll turn it over to you all if there's any additional comments you'd like to make before we close the hearing.
Thank you, Chair Harris. Just one brief comment addressing, for the record, Garrett Weir. That there was a comment regarding a scenario where a party or does not intervene in a PUC case that ultimately is a contested case, but some concern about the ability to seek judicial review if a party doesn't participate when there was inadequate notice. And in our opinion, that isn't a scenario that would be affected by what we're proposing. If a party fails to intervene, there can be discussions about whether there's adequate notice or not separately, but you have to have been an actual party to the contested case. What is at issue here, the nature of the case being contested or not wouldn't change. It would still have been a contested case. So really there, the issue becomes whether notice was adequate, and there's a separate process for adjudicating that issue.
Okay, Ms. Mullen, I see you're unmuted. Did you want to?
Stephanie Mullen for the record. Chair Harris, no, thank you so much for having us today. I have nothing else to add.
All right, great. With that, we'll go ahead and close the hearing on Senate Bill 59, and we will now move to public comment. BPS, please poll the phone line.
Thank you, Chair. For any callers wishing to give public comment, please press star 9 now to enter the queue. Once again, if you'd like to give public comment, please press star 9 now. Chair, at this time, there are no callers wishing to give public comment.
Okay, thank you so much. Mr. Weir, Ms. Mullen, I trust that you'll continue to work with some of the parties who are affected by these bills, and please stay in contact with the committee as those discussions develop. And I believe that's all of our business for the day. We will be back on Monday, February 22nd at 3:30 p.m. and we are adjourned.